Go
This
ahead and.
conference will now be recorded.
Did you guys hear all that?
Yep.
Anyway, oh,
I
cool.
just heard the announcement that the conference will be recorded, which is
Yeah,
fine.
that's kind of awesome. I didn't notice that before. Anyway, so the couple housekeeping things is we will mute people. If you would like to add questions, please put them into the chat window. Chris, do you have a preference for questions? Should we wait until your entire presentation is complete, or do you prefer to receive them ad hoc as we go?
Um, I think that the most effective thing would be to let me do my thing for a little while and make sure that we all are sort of operating from the same set of backgrounds, and then the questions can accumulate, and we can get into them. But I guess, Lisa, feel free to use your discretion uh, if something seems particularly relevant and important to you that I address it right at the time. Go ahead and interrupt. I'll be fine.
Okay. All right, but still, we'll keep the protocol sort of, tee up questions either in your own notes or in the chat window, but we'll give you a big block of time to get through the brunt of your material, unless there's something absolutely earth-shattering that must be broken through. So without further ado, I'd like to introduce Chris Savage from Davis Wright Tremaine. Chris has a very long history in telecom regulation and policy and privacy regulation and policy and legal concerns in general. That's about as much as I'm going to
Yeah,
do there, Chris. So
well,
you can
that's
feel
fine. A very long history is a polite way to say he's old, but I am.
no. I have a similar very long history, so you're in good company. Thank you so much um, for taking this on and being our first presenter in our webinar series. Greatly appreciate it and looking forward to hear what you have to say about CCPA through a Me2B lens.
Okay, well, first, I am Chris Savage. I'm a partner with the firm of Davis Wright Tremaine. And for those of you who aren't familiar with lawyers giving presentations, I need to say that what I'm saying now reflects my own thinking and my own ideas and should not be attributed to any particular client of the firm. We have many of them with many actually diverse interests on these topics. So the fact that I'm saying this doesn't mean that X or Y or Z company who we may represent would agree or disagree. With that said, my plan today is to basically give a high level review of the key features of what the CCPA does for purposes of consumers, give some comments on the background of how it came to happen, which I think is relevant from the Me2B perspective. Uh, Third, since this is supposed to be looking at the law from the perspective of a Me2B lens, I want to talk a little bit about what that I think means to me and what it might mean to others. I think there's some that's still contested ground as Me2B gets rocking and rolling. Then I would give some commentary about how the CCPA fits into that perspective, and then just open it up for a discussion. So first off, the CCPA, California Consumer Privacy Act. It does, depending on how you slice it, 6 key things for consumers. Number one, it gives consumers a right to notice of the categories of data that are being collected about them and the purposes for which the data is being collected. Number two, they have a right to notice, rather, excuse me, to disclosure. A consumer has a right to disclosure of what information a business may have about her. In particular, you can hear about the categories of data that the business has, and those categories are built into the definition of personal information included in the law. The categories of sources from which the business got the information, the purposes that the business has for collecting it, the categories of third parties with which they share it, and then the specific data that they have about you. So lots of disclosure. The law also contains what I would call a weak form of data portability. We'll get to that later on, but the data that they provide to a consumer in response to a consumer request needs to be provided in an electronically readable, convenient format if that's technically feasible. There isn't a provision for directly transmitting it to a third party, so it's not that portable, but it's, again, we'll get that later on, but it's something. You have a consumer has a right to have the business rather delete the information that the business may have about them, subject to a range of exceptions, most of which are sensible. The consumer has the right to opt out of having their data sold, and that's a term of art in the law. And we'll get to that in some length. And then there's a right of non-discrimination. The basic idea is if you exercise your rights to have your data deleted or not be sold or so on, the business can't discriminate against you. But that, again, is a very mushy concept at present. So we can talk about what all that means. So that is the key things that the CCPA does for consumers. Now, it is a long and complicated law. It was not drafted with the greatest of care from my sort of legal technical perspective. And why is that? The GDPR, which is the European version of modern privacy law, was enacted several years ago and was slated to take effect in May 2018. In the spring of 2018, the whole Cambridge Analytica thing was all over the news. And people were freaking out about, oh my gosh, look at all the data that people have about me. Look at the way it can be used. Look at how it can be manipulated. Da, 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 da. Nonetheless, lawmakers, both at the federal level and at the state level, weren't actually doing very much to deal with this. There was lots of hand wringing, lots of nasty statements to the press, et cetera, but not much was happening. California, however, is one of the states that has what's called a citizen initiative process. And what that means is, or I think it's maybe called a referendum, but it's initiative. And what they can do is a citizen can propose a law, and if they get enough signatures on the ballot, that becomes law. Right? Where they get signatures to get it on the ballot, and if it passes, it becomes law. This is a great innovation that was put into place during the progressive era 100 odd years ago. But what it does is it takes, at least in certain circumstances, the process of making law away from the professionals and gives it to the people. That can either be good or bad. Here, on some level, what was going on from my perspective is the people of California, as motivated and organized by this gentleman, Ulster McTaggart, who was behind this, were essentially saying, we're mad as hell and we're not going to take it anymore. So he got the signatures necessary to put his version of the CCPA on the ballot, and everyone assumed, I think correctly, that if it were actually on the ballot, it was going to pass. Now, there's a provision in the law that says, in the Constitution of California, that says the proponent of an initiative can pull it from the ballot by X day if they want to, but if they don't pull it from the ballot, it's on. That provision gave Mr. McTaggart substantial leverage with the legislature, because what he said was, everyone was saying, oh, to pull it from the ballot, pull your initiative and we'll pass something. And he, I guess, comes out of the real estate world and knows a little bit about how to negotiate, and said, well, that's great. I will pull it from the ballot after Governor Brown has signed a law that effectively implements what I'm trying to do. And that happened in May 2018, and so we have the CCPA. But this is not a law that was carefully crafted either by public interest groups or lobbyists or anyone. It was kind of messy. And that's why it's hard to understand how it's going to work, to be honest about it. Okay, so what we have then is this law that was thrown into the California statute books under pressure by virtue of citizen complaints, citizen anger, citizen concerns. It's probably not surprising then that it is not, from my perspective, a carefully thought out, coherent set of principles and requirements designed to implement a unified vision of what consumer online privacy should be. Instead, it's a hodgepodge of we want this, we want that. Notice is good, disclosure is good, portability is good, without putting it all together. Okay, let's take a minute and get to the complicated part, I think, and talk about what a Me2B lens is. If I were putting it into one sentence, my current working definition would be that businesses, notably, but not entirely online businesses, businesses should respect and serve customers as opposed to surveilling, exploiting, and manipulating them. Now, why is that even an issue? Why is it that we think that businesses are in fact perhaps in the business of surveilling, manipulating, exploiting us rather than respecting and serving us? On a historical level, I would say at some level, we all got really lazy during the second half of the 20th century. The second half of the 20th century was the era of the mass consumer market. You went to the grocery store, you went to Sears, you went to big stores to buy nationally advertised products, or if you were looking for a bargain, you bought the house brand in the store. Everyone knew, at Ford, quality is job one. And wouldn't you really rather have a Buick? The quality goes in before the name goes on. Better living through chemistry. There were national advertising campaigns that educated consumers about brands writ large, but mass marketing was not in the model of direct sales. Now, I have to confess, I know a little bit about direct sales. I ended up putting myself through college by being a door-to-door salesman. Direct sales is an odd thing because it's not a situation in which you tell a consumer, gee, here's information you might find interesting. Would you like to buy this? It's a situation in which you are trying to get a consumer to buy something right now. And what happened with the rise of the internet, starting in the late 90s, is the world of advertising and marketing saw how easy it was to track and surveil individuals and decided, therefore, that the right response to that was to find ways to use whatever data you could glean to directly market to people. And so the model of advertising moved from, tastes great, less filling, et cetera, the broad brand advertising followed up by individual experience and word of mouth and so on, and shifted into a mode more like, what we all remember from being sold, the Vegematic, buy now, call the number on your screen, et cetera, et cetera. And there's something weird about that. And I would submit that there are two key things that are really weird about this that make people concerned. And I think it has nothing to do with economics. I think it has nothing to do with sales. I think it has to do with our DNA, literally. The two things that creep people out the most to a first approximation about surveillance capitalism and having, what you see and what you're offered be carefully tailored to you are, number one, the surveillance, and number two, the notion that the data is being shared with and used in some sense against us by third parties. Now, being surveilled, and when I say it's literally in our DNA, think back to the savannas, to the time when we're hunter-gatherers out there competing with everyone else. And there we are in the savannah watching something happening. And what we see in the savannah is a bunch of gazelles, and next to the savannah is a couple of lions watching the gazelles. Who's nervous in that circumstance? The one being surveilled? Absolutely. The lion's only nervous about whether they're going to catch a gazelle. The gazelle is nervous because they're going to die. We are instinctively worried and unhappy with being surveilled. Surveillance is what predators do. Being surveilled is what happens to prey. And so even if we think it's totally legitimate that, this meeting is being recorded and people are listening who I don't know who they are and so on, deep in our DNA of every sentient being, you want to look over your shoulder and be nervous because you're being surveilled. Moving slightly forward in the evolutionary scale, we are social beings. And because we are social beings, we are subject to two things. Number one, people can gossip about us. And number two, people can conspire against us. And so we are intrinsically socially nervous in the context of third parties out of our knowledge talking about us and figuring out how to do something with us or to us. Sadly, surveillance and conspiring with third parties to get us to do something is essentially the essence of online behavioral advertising. The desire to do it is sure. We all want to be the one who's being the predator and not the prey. We all want to be the one who's talking about our friends behind their back and laughing at them, what have you. But that's the essence of what this is in some very DNA human sense. And so it's, I think, natural to the point of being built into who we are for people to be concerned about the surveillance capitalism model, which drives off of those things. And from that perspective, what the Me2B perspective is simply trying to push back against that. Now, in a grand strategic sense, where are we? Surveillance capitalism has sort of run the table, right? In the nature of things, at least under the United States legal system, if something isn't forbidden, you can kind of do it. And so as the internet developed and the technology developed, as the capability of surveilling and analyzing data got so much cheaper and so much easier, people said, well, let's try it. Let's do it. Let's go out and sell ads based not on the context of what's being read or looked at, but on what we know about the person who is actually doing the looking online. And so everyone assumes it works. Now, interestingly, in both in online discussions and in various, stuff you can find, there's beginning to be a little bit of backlash saying, does it really work? Is this really something that's actually going to maximize the value to the business of having all this data to do these kind of individualized, intrusive ads? I don't know. On the one hand, I would find it to be greatly amusing from someone in my perspective that all the anguishing about law and policy is useless because the market will simply drive it away because it doesn't work. That'd be great. I'm concerned because I think that reminds me a little bit of arguments of the sort that you don't need to regulate about fraudsters and deceptive people because they'll get a bad reputation and people won't deal with them. You don't need to regulate snake oil salesmen because they'll kill a few people and nobody will buy from them. In my reading of history, if there is room for bad behavior and that bad behavior makes people money, there will be people who try to make money doing it. And so I don't think it's going to be that easy. And I don't know if Doc Searles is listening. He said he might be. He put out on one of the discussion lists a couple of blog posts saying that, gee, it's going to be tech and not policy that's going to solve this problem over time. I think the tech is part of the answer, but I certainly don't think that there's no role for policy. So from this perspective, how does the CCPA stack up as a Me2B thing? My real answer, I think, is that the CCPA's heart is in the right place from this perspective, but I don't think it was constructed with a Me2B perspective in mind. Other than saying do not sell, giving you the option to say do not sell, which is not as effective as it could be, it doesn't limit what businesses can do with data that they collect. And I think that their heart is in the right place of saying do not sell, but my guess is that what they were trying to get at was the notion that and studies bear this out, we don't mind typically that the businesses with whom we do business know about us, right? The classic example is the coffee shop, right? I was down at the coffee shop this morning getting my latte. This morning it was Emily and Phil behind the counter. I know who they all are. They know what I want. That's great. I have no problem with them knowing everything, lots of things about me. They're kind of my friends. But if I were to discover that they were taking everything they knew about me and sharing it with the shop next door to try to sell me, an additional order of French fries, that would creep me out. And I think the spirit behind the do not sell in the CCPA was trying to get at the notion of limiting third-party access to data that a business acquires about you, but they didn't do it very well, if that's what they're trying to do. And in particular, the way the big platforms work. The big platforms acquire data about you and build a profile of you based on that data, and then protect that profile because that's their crown jewels. So if they want to say, gee, a 63-year-old guy in the Washington suburbs, who owns a house and has grown kids and blah, 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 they know all about me. And so if someone wants to sell something to me, someone comes to the platform and says, send this ad to 63-year-old white guys who live in the Washington suburbs. But they will never tell the advertiser who I am, because that's where it is. And so from their perspective, probably correctly under the text of the law, they're not selling my data. They're monetizing it, but they're not transferring it to any third party. And all the other things that the CCPA does, the notice, the disclosure, blah, 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 those operate from a perspective that seems to me to be, pretty much orthogonal to what the Me2B perspective is, and that is data as a commodity, right? If I have data and it's my data, I have the right to sell it and the right to restrict it and the right to blah, 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 trying to create a market with buyers and sellers of the data. And I very strongly believe that that's not a good model in general to think about consumer data either online or not online. And that doesn't seem to be particularly Me2B perspective. Now, there may be disagreement about that. There's at least a little bit of respect of the customer to say, we recognize that this is your data and what happens to it is yours. But from my perspective, in the real world, the degree of cognitive load imposed on actual people to try to figure out what ought to happen with their data, when they ought to have it, I've been engaged by a couple of clients, sort of the counter client in the counter business that wants to have. I've got people, for example, who want to have the cleanest, most straightforward, most direct, most open privacy policies you can imagine, because their business model entails respecting people's privacy. Even those are, 5 or 6 pages long, and even if you write them clearly, there's only so much you can do. So from that perspective, like the GDPR coming out of the notice and choice model of how you deal with consumer data, the underlying flaw in that model is consumers are not able in real time to process what they need to do. So when all the dust settles, my judgment is, from a consumer perspective, sure, the CCPA has things that consumers are going to like, but it's not really implementing what I would understand to be the broader Me2B perspective of creating a business model in which the companies that are profitable are the companies that actually respect consumers, and the companies that aren't profitable are the ones who don't. So that's my take on the CCPA and Me2B. They're in the same ballpark, but one's in left field and one's in right field. So with that, probably time to shift to start taking some questions.
Thanks, Chris. So I want to just clarify one thing that you mentioned. Well, that was really great. a really kind of thoughtful and deep look at this. So thank you very much. And um, we were talking briefly about Facebook's recent announcement that they would not. I don't know exactly the language of what they said they would do, so I'm going to paraphrase it perhaps incorrectly. So just caveat. Um, they mentioned that they're not going to comply with it, and I'm wondering if, from your point of view, are they getting at that monetization versus selling nuance distinction? Is that what you think they're kind of exploiting, if you will?
Well, let me give a series of disclosures here. Number one is I have not read that article or that statement, so I don't know what they're saying. Number two, my firm does some work for Facebook. I have not done any work in this space for them ever, so understand that I'm not commenting about anything I know about them other than what you just said. But what I would say in response to that is I think it's what I was saying earlier, that the way the law is written, it permits customers to opt out of having their data sold. Now, the law defines sale for these purposes in a very broad way. It's not literally, here's the data, give me a check. Any transfer of data from the business that has it to some third party for really any value could constitute as a sale. And part of the problem with a law like the CCPA, by the way, is lawyers live on precedent, okay? So if you ask me what the antitrust laws mean, it's long and complicated, but I can say, well, here's what the text of the law says, and here's what this case says, and here's what this case says, and so on and so on and so on. So eventually we know how it's going to be applied. There are no decisions at all under the CCPA because it doesn't take effect for another, 12 days, another 2 weeks. So my suspicion is that 2 years from now, we will know for sure what reading of sale is correct. But the way the law is literally written, if there is no transfer of data, if it's not moved from point A to point B for some kind of compensation, the law probably doesn't cover it. And so I would say that's a flaw in the way the law is written. Again, because essentially it wasn't written by professionals, right? It was written by people throwing something together. And then you have the question of whether you have to go back to a variety of things. Would it have made a difference, right? If it had been written in a way that would have substantially directly affected, Google, et cetera, the other big platforms, maybe the response in the political world might have been different as well. So it's an interesting question. So I don't know if that answers your question, but the answer is it sounds to me, I mean, the law is not, from a Me2B perspective, from a consumer perspective, the law has some limitations that you would expect any large profit-making entity to say, I'm going to follow what the law says and not give up vast amounts of revenue that I think I get from it. Now, this is the interesting question that again I raised earlier, that is, does this detailed profile-based, surveillance-based advertising model really work? People have said it doesn't, right? That a lot of ad impressions are fraud. B, a very large fraction, arguably, of the people who are buying X after watching an ad online would have bought X anyway, and it's correlation is not causation. If that's true, then the question is like, well, what do we even care other than it's annoying? I don't know how that goes. Okay.
So thanks. So I think you mentioned earlier, were you going to say more about the weak form of data portability?
I certainly I had planned to and forgot, so I will. There's an interesting bill pending at the federal level called the Access Act. Federal law, for whatever reason, senators in particular love to have cool acronyms, and it stands for something. But it's put out by Senator Mark Warner and Josh Hawley and maybe somebody else, but it envisions data portability as something akin to number portability in the telecommunications world. This is not a coincidence. Senator Warner made his bazillions of dollars as a wireless cellular guy. He knows all about how the Telecom Act works. And starting in 1996, required competing phone companies, required existing phone companies who have a lot of customers, a lot of phone numbers, permit a customer to move to a competitor while keeping their same phone number, which meant it was possible to shift from one to the other. This federal telecom law also required entities to interconnect, telecom entities interconnect, so that a big carrier couldn't say, I just won't take calls from a little carrier. And those two things, working over time, have essentially destroyed the traditional monopoly that landline phone companies used to have. I mean, who cares about their landline phone company anymore? Sorry, Verizon, but there you go. I mean, Verizon's a good example. They think of themselves as a wireless company now. Yeah, they have these landline assets. So what Senator Warner's and Hawley's bill does is tries to take that notion of interoperability and transportability of the critical information between entities and apply it to big platforms and essentially say you have to have an API that a third party competitor can interface with to get my data. So the theory would be if I wanted to move from Facebook to, whatever Jimmy Wales's thing is, I would just say to Jimmy Wales, hey, get my stuff from Facebook, and it would happen automatically. That's a strong form of portability. The ability that I can go to a platform and say, give me my data, and I get a disk with my data, and then what? Then I have to stick it in somewhere or mail it or send it as an email. Every little bit of work and friction that goes into allowing a customer to move from platform A to platform B makes it harder to do. It worked in telecom because it was made insanely easy. And the Warner-Hawley bill is an effort to make it insanely easy in the platform world as well. And just as a legal note for all you guys taking notes at home, there's a case from the old days called Live Universe versus MySpace. Remember MySpace? Where this entity, Live Universe, wanted to impose obligations similar to those in the Warner-Hawley bill onto MySpace as a matter of antitrust law, and the court said no. So that's where we are on that.
Great. Thank you. So I have a feeling there are some people who want to ask some questions. So let's open
Are
it
there
up.
any chats? Yeah, I'm just sort of.
I don't see any in the chat unless I missed it.
Well, I raised my hand in the chat. Can you hear me?
Yes, thanks.
So, if I were to paraphrase what you said about CCPA, it's that it missed the mark because it's not talking about platforms, it's talking about businesses. And the story, and then a lot of your discussion about the Facebook example, not selling your data, and about Access Act. This is all about platforms, and that the fact that we need to regulate. I think I heard you say when you were referring to Doc that we need to regulate the platforms and not worry so much about the businesses. And this goes all the way back to your thing about the savannah in our DNA. The creepiness in the savannah, there was no aggregation, no long-term storage of what was going on in that plane. There was no Facebook or Google taking notes on which lions were looking at which gazelles and using it later. And so my point is, did I get that right? But my Me2B point, because this is a seminar about Me2B, is shouldn't we be looking at CCPA in terms of the platforms being the bees, or not being the bees that we are talking about in Me2B? So in other words, if Me2B makes the same mistake as the CCPA in looking at the businesses as if they were what needs to be certified or regulated or whatever. We would fall into the same trap because the real issue is not the businesses, but the platforms for Me2B.
I think this is probably not your question, Chris.
No,
Yeah.
let me take a stab at it.
Okay.
Um, at a high level, you got sort of right what I was trying to say. Um, the 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 realm of consumer privacy concerns and issues is broader than online and broader than platforms. Okay, so I wouldn't say it was unimportant to focus on businesses. I mean, just we could have a whole long discussion about the whole data broker business, right? Data brokers have existed in one form or another for decades, long before there was a consumer internet.
I'd
And
call those platforms.
well, if in your mind, if that's a kind of platform, then yes. But we have a we have one situation of entities that gather data from third parties and assemble that data and then resell it. That's the traditional data broker. The data broker has no direct connection with a consumer. They just gather data and then sell it. The modern day platforms have direct interactions with consumers, which is where they gather their data. And so in that sense, I think that the CCPA was dealing with a different issue than the platforms. But my conception of Me2B, and Lisa, this could be your question, right? My conception of Me2B is that it's not limited to the platforms. It's a way that businesses should interact with people and people should be able to interact with business. And the whole, with a nod to Doc, if he's listening, the whole notion of tech being more important than policy, or at least important too, is in the old days, when I go to my coffee shop, I don't need any high tech to make my desires known and be treated with respect, right? That just happens because it's real human beings. Part of what's happened is this last 25 years of crazy technology deployment that gives us the online world we have today hasn't developed any means by which those real world things can happen. And so the tech side of it is, how do we take the great feeling you get when you walk into a place where everybody knows your name and make something like that functional at scale in the online world? And I don't know the answer, but that's a tech question and not a policy question. The policy question boils down to, are there things that either platforms or individual businesses might want to do with what they learn about me that we just want to say no to as consumers? And if the answer to that is yes, that's the law side. Lisa, I hope that doesn't trench too much on Me2B itself rather than me as a sort of a policy commentator.
Yeah, no, I think it was fair. I think that was accurate. We are grounded in really the fundamental foundation of the Me2B model. And I'm not saying the Me2B alliance, right? I'm saying the Me2B model, which is a generic concept, right? And
Right.
it goes to the heart of really taking the notion of a healthy human relationship and applying those instinctual, as you mentioned, but those sort of gut level, instinctual social dynamics that we know that have been characterized by psychologists for healthy interpersonal human relationship, taking those dynamics and applying them to this new kind of relationship, which is enhanced by the internet because we actually have a day-to-day, minute-by-minute potential opportunity to have a relationship with some kind of manifestation of a brand or a product or a business. And so should we not apply the principles of a healthy relationship directly to those manifestations of brands and products? And that's what we call the Me2B relationship. And we are focusing certainly on the digital experience. But as you rightly compare with your real world Starbucks example, are you catching my trying to catch my attention? Are you
No, no,
fizzling?
no.
Oh,
I'm sorry. I'm also looking at chats while you're seeing what's on the chat while you're
okay.
talking.
Yeah. So in any case, I
So if
think
I want your attention, I'll do this.
okay. So because I was kind of steering off into space as I was waxing philosophical, so sorry. Um,
That's all right.
but Adrian, I think that you and I have a longer discussion. I think your concerns, which I understand quite clearly, are on the tactics of how the Me2B alliance chooses to tackle that.
No, I was referring explicitly to the comment about the Access Act and sort of how that would the Access Act is, and I put a link to a commentary in the chat for people, how the Access Act is the upgrade to either HIPAA or CCPA or GDPR, because it of exactly what Chris said. Um, it it now the Access Act is explicitly designed. I think it has a limitation of 10 million people or customers or something as a threshold. Is explicitly aimed at platforms. It is not aimed at businesses, which I found interesting. Am I right about the number? It's got a huge threshold.
It is, and I think there is particularly things coming out of Senator Warner's office. This is going to be informed by his service on as the ranking member of the Intelligence Committee. He, on the one hand, he's a smart guy. He's a very successful businessman, and full disclosure, he's a law school classmate. He's a friend of mine. I like him, but he has concerns about the impact of large platforms on the United States political process that intersect with his concerns about excessive use of data and misuse of data in sort of day-to-day economic world. And so when he puts in a requirement that you have at least 10 million people or a billion people or whatever we put in, what he's trying to signal to both his colleagues on the Hill and to the world is, I'm not trying to regulate little businesses doing their little things that don't do much. I'm going after the big guys because I think the big guys are the ones who are creating the problem. But the problem, as he perceives it, isn't just an economic privacy problem. He's got very, very, I think, sincerely held concerns about the impact of all of this on the political process. He knows a lot more than he can talk about, some of which shows up in interesting bits of legislation.
Thanks. So there is another comment, and I think this relates to this discussion about the access law in general. But Colin has asked, Chris, do you think that there is emerging state law that's an improvement on the CCPA?
The very short answer is no. From the perspective, so there is a Mr. McTaggart in California has got CCPA version 2 that he is going to put out as an initiative and get the signatures so that he'll have the leverage to deal with the legislature. I haven't studied all the details of that. One interesting feature is that it would create a California-specific regulatory body to worry about how you interpret and enforce the CCPA. But from the Me2B lens, right, and not trying to say, well, what would businesses want, what would consumers want, but again, from the particular lens of this conversation, I think to figure out what law, if any, would move the ball forward from a Me2B perspective requires stepping way, way, way back, right? Weirdly, the analogy that comes to mind is Lyme disease. So the way Lyme disease works theoretically is you get this parasite and it gets in your blood and it does all these terrible things to you. But it's a pain in the neck to treat. And one of the reasons that it's a pain in the neck to treat is that it will go into sort of a hibernating state, or so I've been told, and cover itself with what's called a biofilm, that is this sort of impervious membrane that looks invisible to the immune system. And so periodically it comes out and fights again, but mostly it's hunkered down trying to protect itself from the immune system. Maybe not the greatest analogy in the way it plays out, but my sense is that because the tech got so easy and so cheap so fast for advertising, ad tech, martech, surveillance, capitalism, all of that, it just sort of ran the field. And what's happening now is people are pushing back in their role as consumers in various ways, but there's a lot of hunkering down that's being done and fighting, lashing out sort of tactically. Well, at least tell me what you've got on it. Well, at least let me say no to this. And one of the things that I think is intriguing about the whole Me2B approach is it's not merely tactical, right? It's not simply this bad thing we think is happening, let's find a way to stop it. It's more of a broader vision of what business relationships with consumers should be, and to some extent once were. And a question of how do we recreate that overall broad environment, which is a big strategic question rather than a little tactical thing. And I don't think there's I got to be fair, there are federal bills are becoming thick on the ground. There are zillions of them, some of them very long, very complicated. I don't have them all in my mind, but I think there's a lot of old sort of notice and choice information as a commodity that people own that they should be able to negotiate about selling, thinking that's embodied in all these bills that is a completely different way of thinking about it than, at least what I understand, the Me2B model of again, creating, to your point, Lisa, creating psychologically healthy relationships between individuals as, empowered consumers and, human beings versus businesses who at the end of the day are also human beings trying to sell us something. I don't think there's any law out there that starts from that broader vision of what these relationships ought to be like, and then figuring out what is the legal framework that is necessary to make that happen. Long answer to your question, Colin, but the short answer was no, but now you have the long reason as well.
So I'm seeing comments come in, but I'm not seeing any specific, I'm seeing observations and then no other questions unless I am missing any. So does anybody have any questions that they'd like to ask Chris?
Wow.
It's unusually quiet.
Well, okay. Well, Lisa, is there anything that you would like me to maybe follow up on that I haven't?
I'll ask a question.
Okay.
I can always come up with questions, as you guys know.
I have one too, so yeah.
Sorry. On this topic of sales, as it is in the CCPA, and the various laws, approaches to these 10 laws that are in the federal system that are all but the Access Act, I think totally inadequate, is what you said. Is the model that we should be adopting who is aggregating and able to make inferences about us, rather than whether data is being moved either with compensation or with good reason or not. So in other words, in the sense of federated learning or data visitation, or things that we're seeing now in the healthcare space, where the data never leaves the firewall, but the intellectual property does leave the firewall, and it's worth tens of billions of dollars. It's the same thing as what you were saying about Facebook, where Facebook never shares that data with the businesses that are their clients. But in effect, they are creating intellectual property, which they are profiting from without ever shifting the data. So, from a legal perspective, as these laws get written, do we need to shift from this idea of looking at the data to the idea of looking at who is learning and then able to sell the benefit of their knowledge rather than the individual targeting of an individual person?
Well, I probably shouldn't be plugging my article on the nature of online privacy, but I'm plugging my article. It's in the January, February edition of this year's Stanford Technology Law Review. But one of the things I drill down on there is trying to identify, essentially asking the question, okay, online entities have all these data and all these profiles, and they can target ads to, when I'm most likely to be vulnerable to buy and blah, blah, blah. And I asked the question, essentially, so what? And the so what, I'm not making the assertion that all targeted ads are necessarily are manipulative or fraudulent or blah, 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 but because they're not. But broadly speaking, it's those kinds of things that make us nervous about people having data about us and then using it to target something to us, right? And one of the things I discuss in the article is that we actually have separate special laws that deal with the direct sales context, right? Door-to-door sales or specific investment advice or the bait and switch where you go to the store and then you can't get the $10 thing you wanted, but they sell you the $50 thing. Those are problematic or can be problematic or need to be carefully looked at, whether that kind of behavior is based on a detailed profile of everything I've done online for the last 30 years, or whether it's just a salesman's instinct that, this old bald guy walks in, why is he here? He probably wants this, and starts to sell me. So there's the worrying about being sold, but then there's a whole separate set of questions of, what about the value from my data? Now, I want to pull a case out of the history here. There's a case out of California where a guy had a form of leukemia that was unusual, and his doctors had him keep coming in for tests and extraction of blood. And what he was doing, what the doctors were doing, was taking his blood and using it to develop potentially extremely profitable treatments without even telling the guy, right? When all the dust settled, it was held that that was a violation of the duty of the doctors to tell the guy what was happening with his medical stuff and blah, blah, blah. But that's kind of the same thing, right? I mean, my DNA is mine, right? Well, it is, except if I give it to the doctor, what does he do with it? These vast, medical databases, what have you. I mean, there's work involved in assembling them. And if it's an interesting equity question as to whether the people whose data is in the database that allows some, company to come up with some bazillion-dollar drug that cures zillions of people, should that value be shared with the people whose data was in the database? I don't know, but I mean, I can make a case either way. That's a different question than the question of, is it my data? I mean, I may not be responding to your question, Adrian, but I see them as two very different things. One is, how are we targeted to be bought? Should we buy things? And the other is, what value can be extracted from a large database that includes some data from us?
No, I think you responded exactly to my question. The example
Okay.
you gave of the doctors benefiting without sharing the blood samples with anybody, but using them themselves to create intellectual property is exactly what I'm saying. And I was just asking whether you think that we are going to have laws, state or a federal level, that actually start to solve the problem which you originally raised around the Facebook targeting isn't sale and CCPA, to actually what you just said, which is exactly what I was asking about. In other words, you know, when you go have coffee with Senator Warner, can you get him to do this?
Well, I can tell him anything I want. That doesn't mean he'll do it. But no, but it's an interesting question, right? Because let's suppose I was talking to somebody, and I can't remember his name at the IIW I was at in back in April and May. Suppose that 100 million people contributed, you know, their biometric data, their DNA, what have you, to a database, and you know, not a private company, let's say the NIH, you know, some research university for the public good figures out how to cure the common cold by virtue of that, right? And so everyone now is happy to buy, you know, $10 worth of really effective cold medicine every time they get a cold. Should each of the 100 million people get a piece of that? I mean, in that way, this is sort of analogous to the question of, if putting aside personal data, I mean, if someone does brilliant chemistry research with federal funding and comes up with, you know, the latest greatest thing that you know helps, should some of that come back to the people as a whole, to the government, by virtue of the original contribution? It's data, in
Well,
a sense, is a contribution in kind.
no, I have an answer to that, which is you're describing open science, and there is no trade secrecy involved. So when you regulate trade secrecy, not the open science.
Well, there you go.
Okay,
So we're getting a
I
little
want to
bit,
jump.
but
I
is
want to
there
jump
anything else?
in. Sorry, we're down to the last 2 minutes, and there is one question that Cam posed that I would like to take as sort of the very last question.
Okay.
In the chat, he says, "What should we do next?" Which I think is a really excellent topic to end on.
Well, my take on that is, you know, we writ large, but certainly the Me2B community, should remember to think big and not small. We Me2B, as I understand it, as I conceive it, is trying to change the business model of online commerce as it's developed in the last 25 years. We hope that that change in business model could happen organically. And, you know, if all of ad tech is a bubble and advertisers realize, I don't need to spend all this money, it's not doing anything for me. If that turned out to be actually true, that would create an opportunity for rethinking what the business model is going to be. If the problem really is people can't express themselves, and the whole Doc Searles VRM effort is this notion that the problem is people don't have a way in the new world to actually express their intent in a way that businesses can readily see and understand and respond to. Maybe tech is the solution. Maybe it just is the equivalent of knocking heads, you know, law coming in and saying, you can't do this, you must do that. But I think the biggest danger for the Me2B community is getting too bogged down at any given moment on particular details. This protocol is the answer. This device is the answer. This particular business model is the answer. From my perspective, keeping focused on the big picture will allow people to make distinctions between this is important right now, this is important in the long term, this is interesting, but maybe doesn't matter a whole lot. And so that would be my what do we do now? Keep thinking about the big picture, because that'll allow us to separate which of the little things actually matter.
Yeah, I think that's really excellent guidance for us, because also it allows for a multitude of possibilities, right? And that's how life is. there are multiple truths and realities and possibilities, and keeping the eye on the bigger picture is very good guidance. So thank you so much, Chris, for your thoughtful discussion. It was really terrific. And thank you to everybody who has participated today. And we will make the recording available for those of your colleagues and friends who couldn't make it today. So thanks, everyone. Have a wonderful holiday, and we'll see you on the next webinar, which will be in February, which will be on the topic of digital permissions. And our
Ooh,
speaker will be Eve Mailer. So,
excellent.
yeah. Thanks, folks.
Okay, thanks everybody. I'll sign off now.
Alrighty. Bye-bye.
Bye-bye.